Very good afternoon, sir.
Beloved students,
Good afternoon, sir.
good afternoon, good afternoon. So, friends, today we have with us today at another a stalwart, I would say, in the IP arena, Ms. Bindu Sharma ji. She is a founder and CEO of Origin IP Solutions, which is one of the leading IP firm in Bangalore. I've been observing and associating myself in a formal and informal manner with Bindu madam. I have got a lot of respects and appreciation for the passion she has for the IP promotion in our country, in line with the vision of Honorable Prime Minister, making India a developed country. You know, if you want to achieve Atmanirbhar Bharat, and if you want to emerge as a Vishwa Guru, I think all of us need to work and promote intellectual property rights. If there is no intellectual property right, then there is no knowledge. If there is no knowledge, there is no power. And if there is no power, you can't emerge as a global leader. So this message all of us have to take with us, and in and day out, whatever works we are doing, we need to apply this concept, of thinking differently, thinking innovatively, and try to improve the way things are happening, the way things we are doing. That is nothing but creation of intellectual property right. So there are many agencies now across the country to help you, to guide you, to secure IP rights. One such good company I know is Origin IP Solutions, which is led by Bindu Sharma ji. Uh, Ms. Bindu is a postgraduate in microbiology and also did LLB from Bangalore University. See, this is a deadly combination. For anyone wanted to make a career in the intellectual property, along with your degree or masters, whatever you are having, LLB is always an added advantage for you, so that you can act as a patent agent. You can also argue the patent cases, and you will be the total personality to represent the entire IP value chain in the intellectual property office, the patent offices, or in the courts also when there are issues related to infringements and others. You can also argue yourself. That is the major advantage of having a LLB qualification. I urge all the students to consider at some point of time you should also acquire LLB, and it opens up enormous opportunities in the IP arena as well. She is also a registered patent agent. That's what I told you. If you are a registered patent agent in LLB, you are like a double-edged sword. Your power will enhance or multiplied several fold. The team of experts from various technical domains. The company has been providing services in the area of patent analytics, performing IP audits of research projects to identify protectable IP. That is where the word protectable IP is very, very important. You all know that. What do you mean by protectable IP? As you all know that we have been teaching you, if you want to protect your IP, it should fulfill the three criteria: the novelty, inventorship, and industrial use. And formulating IP policies and IP cells in institutions, drafting, filing, and prosecution of patent applications. So, till now, yesterday and day before yesterday, we had got a very excellent speakers who talked about IP prosecution. The moment you file application in a patent office, till your application is disposed of, either in the form of a grant of a patent or a rejection. In that process involves a lot of processes, lot of hurdles, lot of complexities. All these things you all have been taught yesterday and day before yesterday. Another important thing today she is going to talk is, the infringement suits and remedies. Once you got an IP, government granted, if you know that you have got a right on that, it's a legal right. If somebody copies that knowledge without your permission, then the case of infringement happened. So how do you overcome, or how do you sue the parties, to get back your rights? If somebody illegally or unlawfully copied your technology, copied your IP without taking your permission, without paying any royalty to you, your hard-earned technology, somebody copied. So this is very, very important in the value chain of bringing IP to the marketplace. So it's a very, very important topic, and with her lot of experience, in this area, Binduji is going to share some of her perspectives with some case studies. And coming back to origin, of course, origin I'm very passionate about origin, particularly Binduji. I am very fond of listening her talks. She talks, in depth and in very simple terms. I've attended several of her classes, and read several of her blogs and LinkedIn posts, what she has posted. That is how I developed a kind of a respect for Binduji, for her passion and for her commitment and for the knowledge, deep knowledge in the subject. She has been a speaker in more than 300 national and international conferences, academic institutions, and corporates. She is a very sought-after speaker. We all know that she is also in the business. She spared her valuable time for benefit of all of you. So make use of this time. Come out with a good number of questions in the area of, not only in the area of infringement suits and remedies, even across the IP value chain. Binduji will be very happy to answer. In fact, when I asked her, Madam, which session you want to take, I sent the program to her. She said, I can manage the entire session, all the 6-day session I can manage. So that is a kind of versatility, knowledge she has got. And she has authored various books, articles, and 3 of her books have been kept in the European Patent Office library. That is the credentials of Binduji. I have a great pleasure in inviting Binduji to share her wisdom, knowledge, experiences for the benefit of all our participants, madam. And the floor is yours, and look forward to hear you.
Thank you very much, sir. Thank you very much for giving me this opportunity to be here with students. It's always a pleasure to be interacting with the students. All students, a very good afternoon. You could all come today for the session in spite of the festival. That is really commendable. Okay, and as sir told very rightly, that IP is one of the good career options for anyone who is at least graduate in science. And if any of you is interested in knowing more about it, you can connect with me. I will be happy to guide you on career prospects, because there comes a time in life when you are really confused what to do in how to proceed in your career. That was a time in my life when I realized that post graduation is not enough to make career in research. I have to be PhD, but I did not have somehow uh, that kind of passion to spend 5 or 6 years on PhD. That was the time that right time somebody guided me that IP is one of the options, and I just walked on that path. So there comes a time in your career when one small advice of somebody, it entirely changes your life. So it will be really my pleasure to guide you on career prospects. But very briefly speaking, if you are at least graduate in science, you can start learning about patent law. There are lots of videos, books, and all free books available. And then there is one exam which you should be writing, called as Indian Patent Agent exam. After you write that exam, you become authorized to practice patent law in the country. So these all things are possible only when you are a registered patent agent. And unlike other areas of law, patent law is one area where even if you are not a lawyer, there are lots of things you can do. And this flexibility is not there in any other area of law except intellectual property rights. And in IP also, it's more specific to patent law. For trademark copyright, you definitely need to be a lawyer. So today I will speak about infringement of. Uh, okay, I'll just put my presentation. Today I will talk about infringement of patent rights. And if there is any infringement, what are the remedies available in law? Suppose I steal your idea and I use your patent without your permission, then what happens after that? How do you stop me? Is something I'm going to talk in this session today. So, China, when you file for a patent, you make a wall around your idea or your invention, your technology. So I will be using these words: idea, invention, technology interchangeably. So the way you have wall, boundary wall of your house or China wall, similarly you have when you file for a patent and patent gets granted, you actually create a wall around that invention. Nobody should jump that wall and use your invention without your consent. Now the difference, many times people file, why should I file for a patent? I want technology to be free flowing. So you file patent not just for making money. Making money is a byproduct, but you file patent for various other reasons, like recognition is most important, right? If I have invented now Alexander Graham Bell has all the rights to be called as first inventor of telephone, right? So Alexander Fleming has all the rights to invent penicillin. So patent is very important. When you file for a patent, it records your date of filing, time of filing, who has filed, who is inventor. So when you file for a patent, it establishes a lot of things as evidence. So that is a reason that you should file for patent if your invention is good. If your invention is not good, it cannot fetch. When I say not good, I don't mean to say technically it's not good. I mean to say if you feel that you cannot sell it to industry, then better to go for paper publication. You should not file patent for whatever comes in mind, because you will be wasting a lot of money. Unlike paper publication, patent is expensive and it is long term. Today you file for a patent and you will have to pay one or the other fee for at least 20 years. So if your technology product idea cannot make money in the long run, then don't file for a patent. If you have excess money, you can file as many as you want, but if you really want sensible patents to be there, then you should select very carefully and make your invention really matching with the customer needs and then file for patent. Official record is that 97% patents don't make any money in their lifetime. Only 3% patents they make money. So now, when you file for a patent, you make a boundary wall around you, and then anyone crossing that boundary wall has to take your permission, and you can give permission only after taking some amount of money from them. There is no specific definition in the Patent Act. So, Patent Act, in fact, does not talk about what is infringement, but they have given rights of patent holders. So, any violation of patent owner's rights is called as infringement of patent rights. If you have any questions in between, you can keep typing in the chat box. We'll address all questions at the end of this presentation. I think in all other talks, you talked about protection of intellectual property. You should protect your trademark. You should protect your copyright, patents. Protection is one part of it. Second part of intellectual property is that uh, you should not encroach upon third parties' IP rights. Okay, you should be in your house, but you cannot jump and enter somebody else's house without their permission. So initial due diligence has to be done when a new product is developed or launched, and then you can really minimize patent infringement risk. And most of the times it is possible to take a different route to prevent patent infringement risk, because if there are some small modifications required in your product specifications and you can avoid infringing any third party's IP rights, then I think it's really worth it. And there are ways to do this kind of due diligence. If we talk about what are the rights of patent owner, if you get an Indian patent, okay, let's go country wise. And it's important to know that patent is granted country wise. Every country has its own patent office. Some of the countries they don't have patent offices, but most of the countries, most of developed countries, they have patent office. So patent is granted by each country. So Indian patent is valid only in India. People in the US, they can use it without your permission. There is no problem. Chinese patent is valid only in China. That means in China, you can use Chinese patent without seeking consent from that patent holder. Now, assuming that you have Indian patent, then you have right to prevent others from making, using, selling, offering for sale, importing, offering for sale and selling that patented invention in the territory of India. That means if I have Indian patent, I can prevent the entire world, each and every person in entire world, without my permission to make, use, offer for sale, and sell directly, and import. Now, if I have Indian patent, patented product cannot be imported in the territory of India without my permission. So, because if I have Indian patent, it can be manufactured in China. Okay, so once it is manufactured in China, it cannot be imported to India. They can manufacture, use in China, there is no problem, but they cannot import the product in India because in India I have my rights. Now if you see the news that comes on patent infringement, you will be able to relate with such news better, because there have been lots of cases between Apple, Samsung, and especially in pharmaceutical industry, every third day you have one or the other case coming up. Now, what is patent infringement? If someone makes, uses, sells, offers for sale, and imports patented product in the territory of India without permission of patent holder, it is called as patent infringement. And patent infringement is a civil offense in the country. Patent infringement is not a criminal offense. So nobody can be jailed for patent infringement. It is only we have civil remedies to take care of patent infringement cases, whereas trademark, copyright infringement, they are civil as well as criminal offenses in the country. So, how does patent infringement happens? Where subject matter of a patent is product. This means if the patent is filed or granted for a product, infringement happens when someone makes, uses, offers for sale, sells, or imports a patented product in India without consent of patentee. But if it is a process, infringement takes place when somebody uses that process, offers for sale, sells, and imports the product which is made by using a patented process. Okay, so violation of patent holders' patent rights is called as infringement in nutshell. Okay, now the question is, can we minimize patent infringement risk or not? Are there any ways to minimize this risk or not? The answer is yes, you can. There are patent searches called as freedom to operate search, which can really help you to minimize patent infringement risk. Clearance search or freedom to operate search is done by the companies in advance when the new product is to be launched, to ensure that new product does not infringe any existing patents. Patent infringement risk assessment can be very well done. And why it is required? See, patent filing is increasing globally. Now you take example of toothbrush. Okay, if you search Google, I want you all to do one exercise, like after this talk, go to Google patents and search how many patents are there for a toothbrush. You will be surprised to see that the patents on toothbrush are in millions. Okay, so now if you have to make toothbrush, uh, will you be able to manufacture it safely, or you will be infringing somebody's IP rights? Is something that has to be looked very, very carefully. So patent filing is increasing globally. Any area of technology you take, there are patents in hundreds and thousands. Now, if there are 100 patents, not 100 patents are relevant for you. Out of 100 patents, there may be 75 of them which are already expired. Okay, so that way we can screen through the patents, and at the end of the day, you will find that only 3 or 4 patents are there which are risky for you. So before you manufacture any product, ensure that you are not encroaching upon anyone's patent rights. Due diligence or screening is necessary before a new product is launched. Uh, Freedom to operate search or clearance search is typically performed before new product is launched in the market. And this search gives a lot of clarity on how many patents are close to your product and how you should overcome the infringement risk. So FTO search or clearance search is done to assess and minimize the risk of patent infringement. And since patent rights are country wise, so FTO is also done country wise. If my product is to be launched in India, I just need to check Indian patents. I don't need to check, US or European patents. Only in checking Indian patents is enough. But I should also take into consideration the patents which are likely to be filed in India next 13 or 14 months. So here only valid patents should be taken into consideration. There may be thousands of patents on toothbrush, but some patents would have been expired and some patents would have been filed in the countries where I don't foresee any business. So slowly and steadily out of 1,000 patents I have to screen, and I should check only the patents which are valid in the territory of India. So how this clearance search is done? If we take one example of probably a cell phone, if I want to apply for a cell phone, then I will segregate. Now, cell phone is a product, right? So in one product there will be hundreds of components. So we have to check. We have to check uh, patents related to each and every component, because if you do a generic search asking for patents on cell phone as a product, then it is not relevant, because in the cell phone there is a screen display, there is camera, so there may be separate patents filed for each and every component. Recently I went for a very interesting meeting. It was a product. I cannot really name the product, so maybe I'll give you some related example. Mm, uh, Maybe we'll take example of cell phone itself. Now, if I have to replicate cell phone, each and every component is protected. Okay. Now, if I want to copy it, how many patents are there? I have no clue right now, because each and every component is patented. Even if I want to copy, because of complexity of patents, I cannot the product cell phone. So here, in order to do freedom to operate search for a cell phone, we have to segregate all components and find out nomenclature of each component. Because just looking at the component, you cannot perform a search. You have to see what is it called in the industry. Then we should identify all patents or patent applications which are related to each component. Okay, and when we extract all patents or patent applications, then we have to categorize the extracted documents based on the relevance. As I told you that for each and every component, if we have patents, we can screen through them and we can remove the ones which are expired, because expired patents are of no use here, because we are doing infringement risk analysis. So expired patents anyways are free to be used. We don't need permission of a patent holder to use expired patent. So that's why for patent infringement risk analysis, we don't need to screen through the expired patents, because they are free to be used anyways. Then when you assess infringement risk for a product, features of the product are mapped with claims of the patent, because in a patent specification there are categories, but patent claims is one section which defines rights of patent holder. So whatever patent holder is going to claim is written in the claims section. So the product features should be mapped with the claims of the patent, and then opinion on infringement risk is given based on the country. Now, laws of each country may be different. So, US, if we do infringement risk analysis for US, then we have to have knowledge about US laws. And similarly, if we are doing for India, then we have to have knowledge of Indian law. And it's not just knowledge, but the case laws, previously decided cases in each country, they also impact your infringement opinion to a very large extent. So for a product called toothbrush, if I found 100 patents which are talking about uh, the uh, the the toothbrush, then first of all I should check legal status of all those 100 patents. Okay, because expired patents are of no use to me. Uh, After checking the legal status, I should screen through the country wise, like, if I want my product to be launched only in India, then I'll screen through and remove all patents which are not filed in India. Okay, so first thing I do is I remove expired patents. Second thing which I do is I remove all patents which are not filed or which are not granted in India. And there are three kinds of patents which you usually find. One is abandoned patents, then is lapsed patents, and then expired patents. As the name explains very clearly, expired patent means which is like gone. Expired patent comes uh, never comes into force again. Expired patent is something which is like gone forever, and most of the time there is no risk to use expired patents. But still, if you plan to use, you should always seek uh, legal advice. Then comes abandoned patent applications. So when a patent is filed, between filing and grant, there are two or three places where some communication with the patent office is required to be done. And if the patent holder has not done it, then patent becomes abandoned. So patent office, they will abandon the patent application. So abandoned also is kind of gone. Abandoned patent application also. So the word abandoned is before grant and the word expired is after the grant. So granted patent becoming null is expired. Patent application before patent is granted, if it becomes null, then the word that we use is abandoned. Then there is very interesting category of patents called as lapsed patent. After patent is granted, there is renewal fee to be paid. Okay, so if the patent holder fails to pay the renewal fee, then patent becomes lapsed, and within 18 months, if you do not pay the pending fees, then it becomes expired patent. Otherwise, there is one chance for lapsed patent to become active. So lapsed patent has one chance to become active, but expired patent and abandoned patents, they don't have any chance to become active. Now, suppose I feel that I'm infringing upon two patents. I can check when they are going to expire. If they are going to expire next month, then I should not be worried about those patents, because I can wait for 1 month, wait for the patents to expire, and then use them rather than infringing them. Sometimes in the product, in addition to patents, there are other forms of IP also which are applicable. So if we are doing infringement risk analysis, we should check for other forms of IP as well. And PCT is a way of filing patent application in multiple countries. So now, if I'm doing freedom to operate analysis for India, there may be some applications which are filed in PCT and they may enter India after 6 months or 7 months. Okay, so it's very important to perform a round of search in PCT and identify the applications which may enter India at later point of time, because these applications, when they come to India, they may impose some kind of risk on us. So PCT application should not be missed. And when we do novelty search, we usually don't put any timeline, because any document published is a prior art. So even if a document is published 50 years ago, it is a prior art. But when freedom to operate search is done, we are interested only in valid patents. Now, if term of a patent is 20 years, then patents beyond 20 years are of no use to us. So that's why FTO search gives you very less number of uh, patents compared to novelty search. So we always put a timeline of 20 or 22 years, maximum 22 years, for to do freedom to operate search, because we are not interested in patents which are expired. And after we have given opinion on infringement, sometimes suddenly you see that there is some change in the file history of patent. So we should monitor the patents periodically to ensure that we are not missing any important update on the patent prosecution part. Now, if there are patents which are likely to be infringed, we can consider taking license. Okay, if I want to start industry on cell phone manufacturing and there is a patent of Samsung, but I cannot go without that patent, so I can request Samsung to give me license. So then it depends upon Samsung whether they want to give me or not, but I can always try to have license from them. And I can also check expiry date of the patent. So if the patent is going to expire in next 1 or 2 months, then I think I'm safe. I can wait for 1 or 2 months and then launch my product after the patent is expired. This point is important that if there is a risk of infringement, you can also check patent holders track. There are some companies which file lawsuits. There are some companies which never file lawsuits. You'll see many big companies also. They file for patents, but they are not interested in enforcing their rights and taking action against the infringers. So this plays a very important role, especially in case of FTO search. If there is no way, but you have to use that particular patent, you can always assess strength of the patent to see how strong the patent is. Because if the patent is strong, then you should not actually use the patented invention. But sometimes if patent is not that strong, then you can take some risk if you want to. Okay, so these are some of the bypass options. Now, who should prove whether there is infringement or not? Suppose this is a kettle and I am manufacturer of this kettle. Somebody in Coimbatore is infringing my product. They made the same design, same metal, same process of making. Who should prove that there is infringement? You can unmute and speak. That Coimbatore company should prove or I should prove? I am a patent holder.
You should prove, ma'am.
I should prove. Okay. So when there is infringement of a product, patent owner should prove that there is infringement. Now, if there is a process to make tea, who should prove? Patent holder should prove or uh, the infringer should prove?
The infringer.
Because as a patent holder, I drink this tea and I feel that it is very close to my patent. How it is made, because it's a process. What temperature, what duration, what is the quantity of tea leaves he has used, what is the amount of sugar that has been used to make this cup of tea. So in this case, patent holder finds it very difficult uh, to uh, to check what. So in most of the cases, in case of a process, patent offices, they call infringer himself to disclose the process which has been used by him to make the product. So rule is simple. If it is a product, patent holder has to prove. And how do you, as a patent holder, if I have invented this kettle, as a patent holder, how do I find it is infringing or not? What are the ways and means for me to find out that company in Coimbatore is infringing my patent rights?
Maybe by being in constant vigilance.
Absolutely. And I can buy the product, compare the specification. I can do a chemical analysis in the laboratory and try to find out.
Are you online, Binduji?
Yes, I am online.
Hello? Hello?
Hello. Yeah, I'm online. Am I audible?
Ma'am,
Anandya, what? Some
We
problem?
are audible.
No
We are
voice.
audible. We are audible, sir.
Dr.
Okay.
Anandya?
Okay.
Ma'am, we are audible.
Other-
I think there is some technical error with the sir.
Yeah, I feel so.
సడన్గా నాకేమైంది
Sir, we are audible. You are audible, sir.
I think he has some issues with
Yes, ma'am. Yes, ma'am.
Okay, so usually infringement is proved. You can buy the product from market, compare it with your product, and if there is overlap, you can make out that there is infringement, and that's how typically. I just want to confirm you can hear me, right?
Yes, ma'am. Yes,
Okay,
ma'am.
okay, fine. Okay, and similarly, when it is a process, you can try your level best to see chemical composition of tea, and if you can prove it is infringement, it is fine. But if you fail to do that, then you can shift burden of proof to defendant, and then defendant should prove in the court the process he is using, and based on that, the courts will decide whether it's really infringement or not. Now, if it is a toothbrush, this is a drawing of patent, okay? And this is the product I want to manufacture. So I should typically be avoiding the same design. If this is a toothbrush and I want to manufacture it, I should see two things. One is design should not be similar, and the technology behind should not be similar. Now, here you see the shape of the button here. One second. Now, here you see that shape of this button is same. Then you have this elongated body here, and it is exactly same in this picture. Who's one? Uh, Apart from that, bristles are there. So, do you think it is infringing or not? Does it look similar or not?
Yes, ma'am.
But now,
What do
if
you?
we look in the other way, like bristles, every toothbrush will have bristles, right?
Correct.
So in this patent, they would not have protected the bristles because every toothbrush will have. Handle also every toothbrush will have. So now, in order to really find out if there is infringement or not, we should check what he has claimed in the patent application, how he has put his application, what are the protected elements, whether he has, and there may be a possibility that you are concerned only about the bristles. When you read through the patent specification, he has not even claimed the bristles. So, giving opinion on infringement would be risky if you have not gone through claims of the patent. Now, we are saying that button here and button here is same, but there is a possibility they have not claimed button in the patent specification in any way. So in that case, you can just screen through what is protected, what is not protected, and focus only on the protected elements, and then see the extent of overlap, and and then proceed with the manufacturing of the product. Now, suppose we have to prove in the court that this design is not really patentable. Patent office by mistake has granted this patent. There is nothing patentable in this product. So, what should we do in that case? I'll repeat my question. Suppose this toothbrush, we should prove in the court that it is not a patentable invention. Patent office has by mistake granted this patent. So how should we proceed with that? What is the procedure available for us?
Post grant objection.
Post grant objection. Okay.
Yes,
So
sir.
generally when infringement notice is sent by the patent holder to the infringer, the first reaction and first step infringer takes is to oppose the patent, because if the patent is invalidated by the court, then there is no infringement anyways. There was a case in Delhi, two companies, Anand Electronics and Futuristic Concepts Media. They were using a technology, digital transmission systems, and they were not aware that Philips had patent on this technology. They did not do any due diligence before starting their company. So Philips had patent protection on this technology, of which these two companies were not aware of. Delhi High Court ordered both the companies to stop manufacturing the VCDs that infringed Philips digital transmission system. So finally, these two companies they were closed. So using technology protected by another company can drive one out of business, and prior risk assessment is essential to prevent such disputes. Now, if you see, before starting their company, they should have done one simple patent search and studied the patent of Philips in detail, and that could have saved them from a long from such a big problem.
Ma'am, is it for product infringement or process infringement?
Sorry, it was a product infringement.
So the same product with this different technology or in the different process, they might have gone for that.
Yeah, they would have. Then again, the question is, we should first of all know details about what they have claimed
Mhm.
in the patent application and how they have claimed. There is all possibilities that this particular technology they have patented. So any product you take, but you are using this technology, it is infringement. But if they have protected this technology only for VCD, then it is a very narrow scope. Now, I told you that if I have an Indian patent, I can prevent other companies from importing the product in the territory of India because I have rights in that particular product. So in 2014, Delhi High Court banned import and sale of Xiaomi mobile devices in India because the companies the company's devices sold in India were found to be infringing upon a number of telecommunication related patents regarding 3G, Edge, AMR that belongs to Ericsson. So Delhi High Court imposed ban on Xiaomi and its local partners e-commerce firm Flipkart. So since this product was imported in India, but there were existing patents, so they could not import the product in the territory of India. And then Flipkart, Amazon also they were banned from selling their products. So this kind of due diligence very well can be done in advance to prevent a situation like this. There is a small company in US, Vernitex. If you get time, you should always read about this company. I find their case studies very interesting. It's a small company, but they have filed lawsuit against all big shots like Apple, Microsoft, Amazon, big companies. Uh, what they do is they file good patents, and when big companies they infringe their patents, then they file lawsuit against them, and the money they collect in the infringement suits is substantial because they file lawsuits against very big companies like Apple. Now, FaceTime video calling service of Apple. This FaceTime was found to be using four patents of Vernitex, and then Vernitex filed lawsuit against Apple. As obvious, Apple argued that it was not using the technology at all. It was using some other technology in its FaceTime services. But then in the court, it was proved that Apple was actually infringing upon Vernitex patent. So Apple was awarded by the court to pay 368.2 million USD in damages for infringing four patents which were used in FaceTime video calling services. Now you see this is such a big amount, 368.2 million US dollars, and this big amount was paid to Vernitex by Apple, and Vernitex has filed multiple suits against these big companies. This is one of the very painful cases of the history. Kodak, in this case, had to pay. You can count the zeros. This many USD to Polaroid in a patent infringement case, and Kodak went bankrupt. Kodak infringing some patents of Polaroid, and Kodak, in fact, took opinion of the attorney also, but opinions were probably not effective and not good. So Kodak finally was forced to shut down its US manufacturing plant. That was 1.5 billion USD manufacturing plant. Kodak had to lay off 700 workers and spend around 500 million cameras back. So in this case, court also ordered Kodak to buy back the cameras which they sold, infringing Polaroid's patents. So Kodak was out of instant business picture business for 15 years just because of this patent infringement case that was filed against Kodak by Polaroid. So patent infringement can be very risky for business, and it can be really, uh, have a serious impact on the business if the due diligence part is not done in advance. Now, what happens in case of infringement suits? What kind of relief is given by the courts in case of infringement? So relief, what is relief, first of all? So relief is a remedy which the court may give in relation to infringement of a patent right. So if anything goes wrong, you go to court, then what is the remedy which is provided? So the relief which court can give is injunction. So suppose there is a pharmaceutical company, they are making a product which is infringing upon my rights. I can go to court and take injunction from the court, and then I can stop the pharma company from manufacturing the product which is infringing upon my rights. And then I can always ask them to pay me damages. So these damages can be, the amount of damages can be suggested by the court. So damages also, it is account of profit or damages. So account of profit means like using my patented technology, whatever money that pharma company has made, they have to pay me profit from that technology. Okay, and also in some cases, court may order and they may seize, forfeit, or destroy the infringing product. So if the company has stored some products in their godowns, then the court may say that you either destroy or return it to me, or forfeit the products which are infringing upon my patent. There are some exceptions in patent law that certain acts they are not considered as infringement. There are certain exceptions, and these exceptions are given in some cases. Like, government can use your patent anytime they want. Um, Suppose I have a house and the government wants to make flyover, so government will take my land anyways. They will give me compensation, but they can take my land. So similarly, in case of a patent, government, if they want to use it for any purpose, they can pay me reasonable compensation and use my patent anyways. So any act of making, constructing, using, selling, importing a patented invention solely for the use reasonably related to development and submission of, okay, I'll explain it to you otherwise. Now, there is a patent which is already in force, and I am a pharmaceutical drug manufacturer. So patent is going to expire in 2024 January. Before that, I am very clear that before January 2024, I cannot launch that product in the market, but I can always do my experiments and take the approval, so that as soon as approval is obtained and patent gets expired, from January itself I can launch a product. Okay, so this can be done. This is called as, like, fair use of invention, and I can use the patented invention for experimental purpose. I cannot make money out of it as long as patent is in force. I have to wait for patent to expire to do that. But for experimental purpose, use of a patented invention is not considered to be infringement. There is a famous case here. It is called as Bolar exceptions or Bolar-like provision. So there is this case of Pharma and Bolar Pharmaceutical. So this was a very historical case which happened in US, and it is related to manufacturing of generic pharmaceuticals. So Bolar here is generic drug manufacturer, and Roche had a patent for a drug called as Valium. It is active ingredient for which it was protected by a patent. So what Bolar did was, Bolar was very much interested in this product Valium, and Bolar wanted to manufacture it, but because of patent, Bolar did not manufacture it during the term of patent. But then Bolar thought that before patent expires, let me take approvals, let me take FDA approval and do my experiments. so that once the patent expires, they can launch the product in the market immediately. So before expiration of a patent, Bolar used the patented chemical in the experiment to determine if generic product was bioequivalent to Valium in order to obtain FDA approval for its generic version of Valium. Then in this case, Bolar argued that its use of patented product was not infringement under the experimental use of exceptions to the patent law. So in this case, what was decided was the Court of Appeals, they said that experimental use of patented invention is not infringement. And what Bolar did was that to take permission before patent expired is not considered to be infringement of patent rights. And this can be done as long as patent is enforced. So experimental use of patented product is not infringement. I can use any patent for teaching purpose. That is also not infringement. So there are lots of exceptions in patent law where use of patented invention is not supposed to be not considered to be infringement. Bolar also argued in this case that public policy in favor of availability of generic drugs immediately following patent expiration justified the experimental use of patented chemical because denying such use would extend Roche's monopoly beyond the date of patent expiration. So in this case, it was decided that experimental use of patented invention to obtain FDA approval to do experiments is perfectly all right, and it is not infringement of patent rights.
So, ma'am,
Yeah.
pardon. Here is the experimental use of this patented product which leads to a novelty, then it will not be a case here, right?
No, I didn't understand your question.
No, so the experimental use of the patented product,
Hmm.
so which gives a novel product, novel invention.
Hmm.
So that still the patented earlier patented company will claim on that. So
No, I don't think so. I don't think so because doing experiments is okay, and you if you want to file patent for that novelty, it is a different invention.
okay,
Okay. And then suppose there is product which is already sold. You buy TV from market, okay? You buy TV from Chroma. So Chroma has made your own money. Now after buying from Chroma, you sell it to whosoever. Chroma should not be bothered about it because Chroma made its own money. So similarly, patent holder also once patent holder has sold product to X to person X, then X further sells to who? So how many people is not problem of the patent holder. So this is also not infringement. I'll just skip this. Okay, then I just want to have some 10-15 minutes for discussion. So sometimes what happens when patent infringement happens, there is requirement to go to the factory, go to the site where the product manufacturing is happening, and there courts need scientific advisors. So because most of the judges they are not scientists, so they need in order to understand the patent infringement, the person has to be very thorough with the mechanical device. If it is like the way technology is growing, there is need to have a thorough understanding of science. So the courts, they have option of hiring scientific advisor, and they can have scientific advisor who can visit the factory and find out the specification of product which is getting infringed and the kind of production it is happening, and give report to the judges, and based on which the judges, they decide the case. Okay, so scientific advisors are very important in order to prove patent infringement. So there is a list of scientific advisors on the website of Indian Patent Office, and that's how the patent infringement cases are decided. I just want to explain to you this previous slide, parallel import. So for every product, every good product, you see there is a gray market always. So if the product is patented in China, it is then there is a sales distribution in India, and this Chinese company has authorized person in India, and they sell this product to this Indian guy. Indian person can sell it to whosoever he wants, because after the first sale of the product, the rights of patent holder, they get exhausted. Okay, so after first sale, patent holder, once he has made his own money, he cannot control further sale of the product. This is in nutshell the concept of parallel import is. So when we say certain acts are not considered as infringement, there are two things. One is experimental use of invention, which is called as Bolar exceptions, and second is parallel import, wherein rights of patent holder, they get exhausted after first sale of the product. Okay, so I'm almost done. It's 3:34. I think we have some 10 minutes for discussion. And
Ma'am,
yeah, please.
uh, I mean, the lecture was very nice, ma'am. Thank you very much. It was
Thank you.
very informative. And now, what I really found both surprising and shocking is how come organizations like Apple and Microsoft don't do the necessary research before filing for a, I mean, before coming out with the product? Because you were talking about a small company back in US who sued giants like Apple and Microsoft. Now, how does that happen?
Yeah, this is actually, honestly speaking, this is actually surprising. Sometimes they miss out. I'll just finish and we'll come to this topic. So one should
Okay.
always take precautions to be safe and not infringe third parties' patent rights. But at the same time, one is like don't use others' patent. But at the same time, if you are a patent owner, you have to be vigilant about finding out if anyone is using your patent without your consent or not. Okay, with this, I just conclude my presentation. Any doubts, any clarifications, you can always write to me. Now we'll come to this interesting discussion. I'm glad that you raised this point. So if this is the case, no big company will be caught in patent infringement suits. Sometimes attorneys, they interpret patent claims differently, when it comes to the knowledge of patent holder, then it is interpreted differently. Now the court's decision may be entirely different. I'll just give you one example. If I tell my child to be at home at 9 o'clock, I have made a rule that you have to come to house at 9 o'clock. But he comes at 9:05 and he shows me his watch and says that it is still 9 o'clock in his watch. Okay, then how do we fix this issue? And if if Vernitex has used a sweetening agent, has used sugar in the patent application, and in order to avoid sugar, I use honey. I feel it is okay to use honey because the patent claim only talks about sugar, right? And I'm using jaggery or honey, so I feel that I'm safe because I'm using something which is not claimed in the patent application. Now, if a lawsuit happens in this particular case, then Vernitex can always say that purpose of sugar was sweetening. So Bindu has used jaggery and honey only as a sweetening agent. So it is still infringement. Okay, so there are lots of tricks in the languages, there are lots of interpretations. So when you are reading the language, you find it very difficult to digest it. Like how can, because in science, 1 + 1 is 2 and there is no other alternative. But if you see in the law, there are lots of possibilities for you to play around with the words, the way patents are claimed, the way terms are used. Do you think how this Basmati patent got granted? Basmati, we all know there was no reason for examiner to grant a patent on Basmati, but but the examiner could grant it because the language which was used in patent was long grain with aroma. Nobody could make out that they are talking about Basmati. It was only after Texmati company started selling the product, we got to know that they are talking about Basmati. There are hundreds of patents in yoga, but examiner cannot catch them because they have not used the word yoga anywhere in the application. The other day we were doing a patent search for something, and it was prime component was sodium chloride, and one patent we missed. And if you have to search for synonyms, you will probably go for common salt, NaCl. Apart from that, I don't know which synonym I should use for salt, but they had uh, used the terminology um, sodium. Okay, so sodium halo nobody will use, right? So this is how some technologies are very well masked by smart people, and it's not really preferred to have that kind of practice. But there are ways people use to mask their patents, and there are difference of opinion when the interpretation of claims happens. Okay, there are
That
questions.
that's very interesting, ma'am.
Yeah, that's interesting.
And I'm sure it would be a nightmare for the attorney when it comes to handling such lawsuits.
Yeah, more than attorneys, it's for judges actually.
And another question, ma'am, you were talking, I mean, you were giving the example of two drug manufacturers, where one is a generic drug manufacturer. So he made use of that patented some technology or something, okay, for his experimental purpose, and someone, the patent holder filed lawsuit, but it was repelled. Now, if yes, the patent has expired, and after that, if that person, if the generic drug manufacturer, would he be able to file for a patent with the
No,
technology
no,
which he has?
no, not really, because it's for one technology, only one patent is permitted. So he cannot file for the same thing. But if he comes up with improvement, innovation, so for that particular improvement, he can file. He can file, but it will be rejected. Nobody can stop us from filing. Filing is just online. You submit the form, pay fees, and it is filed. But it will be
Oh,
rejected later on.
Yeah, for generics,
and
no need of filing patent for a generic
Correct.
product. Yeah.
Correct. Innovative drug is already
oh,
patented, so generic is in India. It is definitely not permitted. We have Section 3D, very famous section of the Act.
okay, okay, ma'am. Coming back to the same example again. So the first drug manufacturer, who's also the patent holder, we have a generic company, and let us suppose we have a third pharmaceutical company. Now, once the patent holder's term has expired, now any pharmaceutical company can manufacture the same drug without
Correct.
infringement. Am I right?
Correct. Absolutely. They can manufacture provided there is no other patent which they are encroaching upon.
Okay.
Because it is highly
And
unlikely for one drug there is only one patent. Solo product patents are very rare. So most of the times, even if it is one drug, but still you need to do due diligence to ensure that there are no other patents.
Madam,
okay,
I do have
and
small, Madam, I do have small doubt. You said for infringement of patents, there is no criminal case, only civil case. Oh. But whereas for trademark and others, there is both civil and criminal remedies are available.
Right, sir.
Thank you.
In Japan, you have patent infringement as criminal case, but not in India. Few countries they have.
Okay, but in India, we don't have criminal
In
case.
India, we don't have. Okay, there is a question.
and
Surbhi Anand, in case of parallel import, what are the criteria for a person to be being authorized by law? Surbhi, it's not authorized by law, it is authorized by patent holder. So suppose I give license to you, then you are authorized by me. So I give license to you and I sell product to you. After that, you can sell to whosoever you want. Okay. Then another question is, in India, can private company use patent rights who all come under three parties under Section 101 of Patent Act? Section 101 is rights of the government to use invention. Uh, Private company use patent. I think there is no discrimination on private companies or governments. Okay. I think I understood question wrongly. No, private companies cannot use under Section 101 because 101 is exclusive for government use of patent rights. Private, it's not meant for private companies.
And ma'am, at the very beginning of your session, you mentioned that just don't go for filing a patent for whichever idea you get, because in the process of filing a patent, you need to spend a lot of money. So, can you please tell me roughly what is the minimum amount which a person needs to spend if the patent gets granted and he wants to renew it for the entire 20 years? I mean, from the beginning to the end of the 20 years, how much roughly a person needs to spend?
Okay, see, I'll just give you the broad range. Filing a patent application at least cost you 50 to 60,000 rupees if you have a reasonably okay attorney. There may be people less than it, and there may be people more than it. So 50 to 60,000 you can expect the initial charges, and maybe after 1.5, 2 years when you have examination report, you may have some 50, 60,000 rupees of budget because one hearing mostly comes during prosecution. So responding to office action and hearing. So 1.2 lakhs, okay. And after it is granted, it's not much. After grant, it's not much. And annually you have to pay. Initially it's less, it only becomes little more, but it's quite affordable. Maximum is I think 5 or 6,000 rupees per annum.
So you were talking about some paying 50 to 60,000 for the attorney during the filing. Now, can you please
Yeah.
tell me what role does that attorney play while filing the patent?
Your attorney or patent agent will draft your patent specification because drafting is your major expense. Uh, Drafting has to be done so that you have complete coverage, and chances of approval are high if it is drafted well. If it is not drafted well, examiner will raise lots of queries, questions. Your hearings will be messed up, and at times there are patents poorly drafted that in case they want to license it, they cannot do it because nobody will buy that patent because of its poor draft. So you have a lot of difficulty to sell such patents or to license such patents if it is not drafted well.
Okay. And coming to the basmati rice thing, ma'am, is basmati rice a patentable object or does it come under geographical indication?
See again, same answer. We don't know how they have claimed, okay, but otherwise, product of nature, they are not patentable. But tweaking it a bit, you can manage to have it. Okay, and lovely audience. I thoroughly enjoyed because if audience is interactive, the speaker gets kick to explain, and it's really nice, very nice audience. I really appreciate.
Ma'am,
Exactly.
a small,
Yeah, Kishore, go ahead.
ma'am, at the starting of the presentation, you said that a product manufactured in China cannot be, if it is patented in India, cannot be imported.
Correct.
What is that? Can you be bit clarify that if it is patented in India, it cannot be imported again to India.
See,
Can
see,
you
if
be
you have a patent in India, you can prevent everyone from importing it because if it is patented in India, anyone can manufacture in China, right? But manufacturing is fine, but importing is infringement because you have patent rights in India.
okay?
So it cannot come to India without your permission.
Okay, but can they manufacture, no?
They can manufacture. If you don't have any patent rights in
Okay,
China, they can
okay.
definitely manufacture. If you want to prevent them from manufacturing, you have to file your patent application in China.
That will not be an infringement then.
No, no,
Okay,
it will not be infringement.
you will have
Filing,
to.
the infringement never happens by filing application. Infringement happens only by illegal use of patented invention. So even if your application is similar to any existing patent, filing never causes infringement.
Okay, thank you.
Any more questions? Very difficult to get Binduji.
No, sir.
Operation
No, you
very
can call me
busy.
anytime, sir.
Attorney.
No,
Ma'am,
you can
last
call me
question.
anytime, sir.
Yes, I have one. Ma'am, you were talking about that patent agent practice, and for a person to become a patent agent has to clear that respective examination. So, can you help me with uh, the process involved in, or can you just tell me what is the basic process involved for preparing for that exam?
See, you should be thorough
Notification
with
has already
Patent
come.
Act. Yeah, you should be thorough with patent law, drafting patent specification. We have very affordable courses. You will get in Udemy for 500 rupees or so. You should see what is like the which day you have the lowest price, and very affordable
Okay.
because now we have given all our study material only for people to use. We have initially we made money when we wanted, but now I think it's just charity, and we have books in Kindle. We have both modules. Last week we have put everything on Kindle, so you have everything available at throwaway prices. You can subscribe to our courses, and there are people who have cleared this exam only by reading our content.
It's one of the
Okay,
best
ma'am. Fine.
material. Yeah, it's one of the best material.
Okay, I will send link to sir, and he will forward it to you.
Sure.
Okay, ma'am. Thank you very much.
And the notification also has come already. Anyone interested to appear for this examination?
Yeah, yeah,
The examination is on January 7th, I suppose. Yeah, you can
yeah.
also go to the Indian Patent Office website and download the entire process of how to register for the examination. There are a lot of model papers are also available, previous year's papers. So read those papers and also read study materials available for the Indian Patent Agent examination. So if you are definitely you will be able to crack that.
Yeah.
This Indian Patent Act, that act you need to study thoroughly all the sections, all the rules, all the forms, the fees, the timelines. If you are able to rather by heart it, you will be able to crack it. That is what our experience. And of
Thank
course,
you, sir.
people who have got hands-on experience who are practicing, for them it will be much easier. But people who are as students, they may not be having that kind of a hands-on experience. For them, just only remembering and understanding the Indian Patent Act thoroughly. There are, I think, 180
Okay.
or 160 sections and the rules. So you need to really remember that it is a memory test basically.
Yeah, yeah, I know.
Okay, sir. Thank you.
A lot of opportunities are coming. Recently, Government of India has also announced, to recruit 553 examiners, patent examiners. Eligibility is only science and engineering degrees. So that opportunity is also available for people who wanted to make career in intellectual property rights.
Yeah, patent
Sir,
examiner is also good area if you want a government job, and because most of the examiners after 4 or 5 years of experience, then they leave the job and they join law firms and they do well. So it's good area.
ma'am, is patent agent and patent examiner are these two different people?
Yeah, they are different people. Patent agent will draft your application. Patent examiner is Government of India. He will examine and approve your
Okay.
patent.
And I mean, what is the eligibility to become a patent examiner?
I think it must be graduate in science.
Yeah, science
Yeah,
or engineering?
engineering.
Science, engineering,
Yeah,
technology.
technology.
And is there any examination for that?
Yeah, yeah.
Yeah, there is examination, and then there is extensive training they provide after you are selected.
The
But you
notification.
must try. You must try for it.
Okay, fine.
If there are no other questions,
Last question. That's,
last question, Ravindra. That's what I was waiting for your question.
Ma'am, just actually I want to recall, I misread actually the particular part because of my internet slow connectivity. Just while you are explaining about the acts which are not considering for the infringement, so which is a parallel import and a fair use of invention, and what else, ma'am? That's two only I got it.
Uh,
Anything missed out?
okay. Actually, I will have to have. Should I send you two of my videos on this topic?
Thanks.
You send it with
Ravindra.
one, I will share it with.
I will send you Udemy link, Kindle link, and 2 videos.
And also your presentation, PPT if possible.
PPT.
I will send, sir. I will send you right away.
Super. Thank you.
One last question. Well, you were talking about just going through the history of patent holder, whether he's going to take his patent infringement seriously or not. I mean, I really couldn't get it because if
I
I'm
didn't
a
want to
patent,
elaborate. I didn't want to elaborate on it because, but here it's not being recorded, so that's okay. Now, see, there was one company we were doing infringement analysis for that, and it was uh, okay. I think let me speak about it. Honda wanted to check whether it is infringement or not. The other company is Hilux. Hilux patent was very risky for them, so they thought that if they incorporate this in their tires, it may infringe Hilux patent. When we checked Hilux patents, quality of patents were very good, and there was high risk of infringement. But then we checked history of Hilux. But in the past, till date, Hilux has not filed even a single lawsuit. So that means if you infringe, they will not file, most likely.
I
So
mean,
you can take some risk.
isn't that somewhat shocking, ma'am? Because if I'm a patent holder, I would definitely sue a company which is infringing my patent because it
Some
was a
companies
loss of
don't
money.
bother. Some
I
companies
mean,
don't bother. They said we don't want to be a litigant company. On the other hand, there are companies, even if you are not infringing, they will keep sending notice like Autodesk and all. I mean, every third day, yeah, I mean, they just harass the clients like, you are using my pirated product, this and that. Somebody has in your company downloaded the product. They are threatening their customers itself that you have taken 2 licenses and third person is using illegal license. So, but on the other hand, there are companies like Hilux in the past till date, they have never filed a lawsuit. So if that is the case, then we can take some risk sometimes. But I don't
ma'am,
usually suggest this in local,
yeah,
on common platforms, but I thought maybe it's not being recorded, so I can speak about it.
yeah, that's what was really confusing me, ma'am. Because a company is okay accepting losses because at the end of the day, companies are doing business and means profit. So how come they are ready to face losses intentionally?
But it's
It
all
is
about strategy and interest. Some companies, they are growing so much that it doesn't matter. That money they recover and the botheration, it's not worth their time.
okay. Okay.
Now if I infringe Toyota's patent, what will Toyota achieve from me? They can't even recover that kind of money from me. So they say, okay, you be happy, keep using. They may probably send me one letter, but it doesn't matter to them.
I should fight with a big player where they
Yeah.
have a lot of money.
And if your patent is infringed by a big company, you are really lucky. You can expect something good out of it.
That's true. That is an opportunity for lawyers.
And if somebody infringes your patent, that itself is validation that your invention is good.
Right.
Like
Okay.
Vernitex.
Thank you.
Ravinder, you wanted? Okay.
No, no, sir. Actually, Apple. It's like Apple versus Vernitex. Vernitex had grabbed a good money from against
Yeah,
the Apple.
absolutely. It was multiple fold of their annual revenue.
Jackpot they got. Even if the license, they would not have got that kind of money.
Correct, correct.
Okay, friends, if there are no questions, let us, all of us, thank Ms. Bindu Sharma ji for her excellent talk. See, the quality of talk probably all of you might have enjoyed, the live examples. A person's knowledge can be assessed by the way they talk, the way they present, the kind of examples, they quote. So we could see all the elements in Ms. Bindu Sharma's talk to really gain some new knowledge and also to I feel that you all agree with me in saying that Dr. Bindu Sharma is one of the best speaker for us, and she has got in-depth knowledge about the prosecution part and what happens in the Indian Patent Office and after the Patent Office, that is in the courts. She has the experience of both the domains. That is why she is a full personality in the IP arena, I would say. That is why she handled the entire 6-day program single-handedly. That's what. So that is the.
Very kind of you, sir. Very kind of you, sir. And I'm really grateful to you for remembering me and calling me for this
Yeah,
session.
it's not. You always remember good people and the quality people.
Yes.
Though we never have interactions, but I could sense the skills and the passion what you have in the area of IP. Of course, that was further affirmed, after hearing so many of your lectures in YouTube, after joining myself here as IPR Chair Professor. So I have taken you as a mentor rather any of my delivering lectures. So that is how we got connected again through this opportunity. I look forward for your continued engagement, participation, and guidance. Friends, let us give a big round of applause to Ms. Bindu Sharma.
Thank you so much.
For sparing your time for us. Thank you so much, madam.
Thank you, sir. Good day.
Yeah, thank
Have
you.
a nice weekend. Thank you.
Friends, we'll take a 5 minutes break till we're supposed to start the next session at 4 o'clock. If you want to take, otherwise we can continue. The next speaker is also readily available with us. What do you say? Shall we continue or you want break 5 minutes?
At least 2 minutes. Please.
2 minutes. Only my request is people should not leave the platform. The moment if you give a break, started dropping. Already 7 people gone. Okay. Please tell me when shall we start, then we will request the next speaker to come and join the session. So I think with today's lecture, I think the academic session would be over. Tomorrow there will be exam and feedback and valedictory. So feedback, there is a form will be circulated in the morning session. Giving feedback is a mandatory for getting the certificate, So please give your feedback, critical feedback, not saying everything is fine, we are happy and all, but you also please help us to identify some of our weaknesses, some of our shortcomings, so that we will be able to incorporate or strengthen our those weaknesses, to become strengths and deliver the courses as per the expectations of the participants. Unless you give that candid feedback, we are not worried. We don't want also. Everybody should say the same thing. Please analyze it. See, nobody is perfect. Nobody will be having all the strengths. Definitely, there will be weaknesses. There will be some shortcomings. So, in terms of quality, in terms of resource persons' delivery, and the pedagogy as such, what are all the improvements required? So kindly think we are giving time till tomorrow. We have another 24 hours and try to help us to design the programs in much better manner. We are also in the learning phase. There could be some shortfalls or shortcomings in our program as well. We all know that these IPR chairs were established by Government of India and some of the premier institutions across the country. I think so far I think 14 or 15 chairs have been established, which are functioning effectively across the country. We are one of them. And we have a small team here, Dr. Anandya, Dr. Ashok, me, and supporting staff. As an experimental basis, this is our first course. We are also about 2 years old in this university. So to reach out and to educate our students, faculty members, we started this program. Fortunately, we got very good resource persons, all of them. You might have seen through their lectures how experienced they are, how passionate they are to share their knowledge with all of us. So if you all support and bless us, definitely we would like to continue this kind of events in the time to come. You can also tell us what are the other kind courses we should conduct for your benefit. We can get the best resource persons because we know where the talent exists in this IPR area. We can reach out to anyone in the country or even outside the country also. We can invite them. If you have support and participate in these programs, organizing these programs is really a big pain. See, at least if there are 100 participants, that gives the motivation to the organizers as well as the speakers. If there is less than 100 participants, we don't feel that kind of a kick or enthusiasm. So that is what the awareness is not there, and IP is emerging as a very important subject, and but people are still not taking it very seriously. The moment if you all consider it useful and spread the message, I think many people will come and join and try to learn the new concepts of intellectual property rights. That is what our request to all of you. Spread the message.
Excuse me, sir.
Yeah, Ram.
Sir, can I ask you a question regarding your IP chair responsibility?
Yeah, please. What is your background, Ram? You are from where?
Well, I'm from Vizag, sir. I happened to speak to you a few days back. I mean, few days back in the sense, few weeks back regarding this workshop. So I'm an assistant professor in Gayatri Vidya Parishad, Rushikonda Engineering College.
Okay, wonderful.
In the Department of Electronics and Communication.
Yeah.
And I'm pursuing my PhD in Andhra University as a part-time scholar. So, sir, my question is, do you offer any certification courses in Andhra University on IP?
This is the first course. And we made the IP as a mandatory credit course for all our PG students and some programs in UG. We teach IP there one full semester. But as of now, there are no courses. This is the first course on a pilot mode we tried. And our mandate is to offer also a PG diploma course also in IPL. We have to prepare ourselves for that.
Okay.
Yeah, our mandate given to the IPR chair is to create awareness through different mechanisms, organizing workshops and conducting FDP programs, conducting this kind of certificate programs, and teaching IPR across the disciplines, and offer even diploma and PG diploma courses also. So we'll be doing it probably the nearest future. Not able to get the manpower also. Now I have 2 research fellows supported by DPIIT, but the criteria for that is they should be UGC CSIR net qualified. I'm not able to get CSIR UGC net qualified candidates in this region. Now, if anyone have got some reference, please forward their names to me. I can take them immediately. 2 positions are available. So IPR area, this is also, though there are opportunities, but we are not able to get the required resources. See, earlier 2 JRFs were there. They got After serving here, they got the better jobs, high-paid jobs. They have gone. One almost he got triple the salary what we were paying here, and the other girl recently she worked hardly for 2 months, 3 months. She got assistant professor Getam, and she has gone there.
Oh. Sir, is there, is there a scope doing PhD in IP also?
Yes. We are all recognized. We have two research supervisors in IPR Center, Dr. Ananya and myself. We can also guide. It is a transdisciplinary research hub. You can register any discipline, irrespective of your discipline. You can do PhD in IPR. In fact, that is also one of the mandate given to us by the ministry.
And what is the eligibility, sir, to do PhD in IP?
Pardon me?
What is the eligibility, sir, to do a PhD in IP?
Any postgraduate? I see. Only eligibility is that you have to qualify in that APR set, that is one channel. Okay. The other channel is through executive PhD. Executive PhD, you need to pay higher fee. You don't have to qualify in the, I think, APR set.
Okay. Sir, coming to APR set, I mean, in the recent APR set, that's how I managed to get a PhD seat. So, in which stream am I supposed to write APR set to do PhD in IP? Because I wrote it in my electronics stream.
Yeah, that's a good question you raised. But that is what it is, a multidisciplinary nature. We got a clearance from the university from any branch. Whoever wanted to do PhD, they can do. But I think you can do only under the transdisciplinary research hub in whichever department or whichever post graduation is, say, for example, mechanical. The mechanical engineering department only will give you the PhD. That's what that transdisciplinary research hub guidelines says. You can do PhD with related to your mechanical and any of the processes, any of the products, any of the devices related to mechanical engineering, and link it up with the IPR.
Okay, sir.
But the mechanical engineering department gives you PhD if you are a mechanical engineering student.
Okay, sir. Thank you.
Yeah. Thank you, Ram, for raising good questions. Yeah. I think Mr. Ashok is already here. Sorry, Ashok.
It's okay, sir. Good afternoon, participants.
Yeah, Ashok is also known to all of you. He is also our IP attorney. Like many top-class attorneys, they have a basic degree in engineering and law degree, and he obtained his IPR law from IIT Kharagpur, and he is also.
Yes, sir. I am from this department, so no need of introduction.
Yeah.
So I am Ashok. I worked in IT industry for more than 15 years in India, US, and Australia, and then I did my LLB honors in intellectual property rights from Indian Institute of Technology, Kharagpur, and my LLM is from World Intellectual Property Organization, Geneva. So after that, I am here. So hope I have taken one session, and hope I'll be taking one more session. So sometime back, actually, few participants were asking about slides. Actually, I have shared day 1 and day 2 and day 3 slides. So day 4 slides are pending, and actually we requested Dumane sir to forward his slides. And day 5, my slides I will be sharing after my talk is over. And we will request Bindu Sharma ma'am to forward her slides as well. Is that okay?
Okay, sir.
Yes.
Okay, let's start our presentation. So can you see my presentation? Slides?
Yeah, yes.
Okay. Bindu Sharma ma'am, actually she has covered some of the exceptions. Actually, my topic is all about exceptions. In detail, we're going to discuss about exceptions to infringement, and also we're going to discuss about some of the basic topics which have been covered even in the previous classes, so that we'll be connected to exemptions. So if you take a patent regime, what is the patent regime purposes? Whatever the patent regime's objectives that are enshrined in Section 83 of the Act. Patent regime's purpose is at one side we have to secure the inventions against unauthorized use and grant the patent to the inventors. So that is basically for the applicants. So another side, you have to simultaneously you have to promote technological innovation, dissemination of knowledge, and promotion of public health. So basically, these three categories talks about welfare of the public. So at one side you have to protect the inventors. At another side you have to look for the welfare of the public. And to balance these two things, one side owner will be getting the patent rights, and another side obligation. And third component is exceptions. That is what I'm going to discuss. And coming to the welfare of the public, so that is in detail, that is explained, enshrined in Section 83 of the Act. In the next slide, I'm going to keep that. So these are the objectives of the patent system. So in detail, actually this slide has been covered in the Dumane sir session. So basically Section 83 of the Act says that what are the objectives of the patent system. So the total crux of the slide is exclusivity granted to the patent holder shall not stop the working of a patent by government for public non-commercial use. For example, if government want to use it for the purpose of the public non-commercial use, so without consent of the patentee, government can use that. So like that, there are several exceptions are there. Somebody asked us about, what are the exceptions, detailed exceptions that are there in the Patent Act. So we're going to discuss about exceptions. So broad classifications of exceptions are, the first one is experimental or scientific use of exception. This is covered in Section 47(3) of the Patent Act. And second one is a foreign vessel exception. In detail, I will discuss about what is foreign vessel exception. And third one is public non-commercial use exception. So if government want to use it for public and it is non-commercial, then government, without the consent of the patentee, they can use the invention without the consent of the patentee. So the fourth one is the regulatory use exception. This is also called the Bowler exception. So Bowler exemption and experimental or scientific use exception, both are different. I just wanted to emphasize. So we will be discussing that as well. And the fifth one is a prior use exception. So before 2005, whoever files the patent, so they have some exceptions that we're going to discuss. And the sixth one is exhaustion of patent rights and exception, patent right exception. So somebody was asking questions about what exactly the exhaustion. So we will discuss about what is the doctrine of exhaustion, and there are three kinds of exhaustion that normally countries prefer. That is the national exhaustion, domestic, international exhaustion, and regional exhaustion. So we will discuss about all these exceptions in detail in this session. So first, experimental or scientific use exception. So what are the advantages with the experimental or scientific use exception? So actually the patentee get the rights, exclusive rights to exclude others from making, using, selling, offering for sale, and importing. So if you give the exception, what is the advantage? So basically the advantage is it is the welfare of the public. So as mentioned in Section 83, that is the objective of the patent regime. So to support that, these exceptions has been given. So at one side, patent rights should be protected. At another side, obligations should be given to the patentee, and exceptions also given so that the welfare of the public will also be taken care. So that is the main goal. That's the reason we are discussing about the exceptions. So coming to the first exception, this is the experimental or scientific use exception. Advantage with this exception is it allows patent use for experimentation and research. So any individual can use for experimentation and research. We will discuss who is individual and all. Somebody asked about question like, who is individual, whether it's a private company or public company. We will discuss about that. And supports scientific progress without infringing on patents. So you can take this exception and that is not treated as a infringement. So this exception is enshrined in the section 47 of the Patent Act under subsection 3. So basically this exception gives for product or process. Here product can be mission or operators or articles or process, and any person, individuals, can freely use or created patented items solely for experimentation, research, teaching, and instructing students. For this purpose, here individual means any natural person, even it is a small entity or large entity, even a big companies also comes under individual. So these people can use the patent without the patentee approval, consent, and you can use it for sole for experimentation, research, teaching, and instructing students. For example, a new method of producing biofuels, any researcher at a university can use this method in their laboratory to understand its effectiveness and potential application without violating the patent rights. So this is the one exception. So this is not comes under patent infringement. And second one is foreign vessel exception. So what are the vessels? I will discuss what are the vessels here. So the advantage with foreign vessel exception is it permits temporary patent use in foreign vessel within a territory. Basically, this is for smooth transition between one country to other country, smooth travel between one country to other country. So and also balances patent protection and international trade needs. So we will discuss about these things further. So normally patents grant exclusive rights to inventors, allowing them to control the use of their inventions, that everybody know. So special consideration for foreign ships and claims using patented inventions in India. So what are those special considerations? So especially for the vessels, here vessels are nothing but foreign ships or planes or including land vehicles. So foreign ships or planes which are temporarily or accidentally in India's airspace or water, if they come, or any land vehicle. So land vehicle normally, if it is owned by a person ordinarily resident of a foreign country. So in these three categories, exemption applies if the ship or plane is registered in another country not owned by an Indian entity. So these cases, the patent invention must be used on board the foreign ship or plane. So in these three cases, the exception will be there. So, but the condition is you should violate, you should do the invention of the patentee of the respective country, and that should be on the foreign ship or on the plane or on the land vehicle. So invention should contribute to the other operation or improvement of the vessel. So actually this kind of provision actually we have taken from the Paris Convention. So they clearly mentioned that. So you can infringe the patent which has done on the vessel. Here vessel is foreign ship or plane or land vehicle of the territory. For example, in India, so if any foreign vehicle or foreign ship or foreign place comes for temporary or accidentally, if they violate the rights of the patentee, still that is considered as not a patent infringement. So, but that invention is used exclusively for the needs of the vessel. So this is the very important point. So you cannot infringe some other thing. So it should be used exclusively for the needs of the vessel. So basically this provision has been given. The invention is to facilitate smooth cross-border travel and interaction between the countries. And reciprocal arrangement. Actually this provision mutual agreement between the countries. For example, if one country vessel can use patented inventions in another, the same privilege extended to other country vessel. For example, this provision, if Pakistan is not giving, we are also not going to give. Tomorrow, if Pakistan vessel comes in their patent act, if this reciprocity provision is not there, and if they can, and if our Indian ship goes to their territory and temporarily, if we infringe the patentee of some Pakistani applicant, I mean patentee, then that is considered as an infringement, because this is the reciprocal. If it is there in some other country, so then we will give for that country as well. So that is what reciprocity. Anyway, you know, this is supported by Paris Convention connection, and also it what are the advantages also we discussed, like promotes international travel and cooperation between the nations, and it also enhances the ease of movement for foreign vessels, fostering diplomatic relations and economic interaction. So far we covered two exceptions. So any doubts before I go into the third exception related to foreign vessel and as well as experiment? Shall I go ahead with the third exception?
Yes, sir.
Okay. So third one is a public non-commercial use exception. So advantage with public non-commercial use exception is like it enables patented items for public welfare uh, and also ensures critical resource for healthcare and public service. We're going to discuss about these 2 points in the further slides. So uh, a public non-commercial use exception, actually it is enshrined in section 47, subsection 1, 2 and 4. Section 47, subsection 3 we have covered already, which talks about experimental and research exception. Now remaining subsections under section 47, it basically discusses about government use, especially for public non-commercial use. So it outlines specific conditions after grant of the patent. So this is primarily address the government usage, product or process. If government wanted to use, either it might be product or process. If it is for public non-commercial use, yes, they can use it. So subsection 1 under section 47. So patent items can be imported or made by government for its own use. So if you take one example, suppose a company patents a new type of solar powered water purification system. According to this condition, the government can import or build this system for use in its public facilities like government offices or public parks. So if government thinks that this is useful and it can be used for public non-commercial purpose, and here in this example it is a product, and you can see it can import also. So patentee right is you can exclude importation as well. So if government thinks, government can use. And another subsection under section 47 is process used by government. Government can use patented process for its purpose. This is about process. If a company holds a patent for an innovative waste recycling process, the government can use this process in its waste management facilities without infringing on the patent rights. So this is about process, and that is about product. So government basically can use it for any process or product for non-public, public non-commercial use. So another condition under section 47. So this is about public health. So if government wanted to use any invention which is patented for the use of public health, then it can take that, and that is not treated as a infringement. So the fourth exception is a regulatory use exception. So this is also called a Bowler exemption. So the advantages with regulatory use exception is it allows a patent use. So Bindu Sharma ma'am covered partially. I'm going to cover it in detail. Allows patent use for regulatory and compliance. This is basically for pharmaceutical companies or agrochemical companies, for example, like fertilizers and all. If they wanted to launch any product or process or whatever maybe, if they wanted to launch, they cannot directly launch. They need some regulatory approvals. So they have to submit their results, then regulatory will approve that, then only they can launch. So it also supports testing and assessment without patent infringement, especially for those purposes. The exemption has been given. For example, I will discuss about these things in the next slide. So actually this has been enshrined in section 107A of the Indian Patent Act. which introduced a crucial concept known as the Bolar exemption. So why it became a Bolar exemption, ma'am already covered. So this case law, US case law, Roche versus Products, IMC versus Bolar Pharmaceutical Company. So after this judgment became an act in the United States of America. So this kind of exemption has been given through TRIPS agreement. So TRIPS means that is the international agreement enforced by it is enforced through WTO, because we all are members of TRIPS agreement. So this regulation also, that is Bolar exemption, also has been added under section 107A of the Patent Act. So WTO is the World Trade Organization. So almost more than 188 countries are part of, almost the entire world is part of WTO. So there is obligation that each and every country has to comply with the TRIPS agreement. So TRIPS agreement means that is the international agreement on trade related aspects of intellectual property rights, so that the trading will be smooth. Through TRIPS agreement, minimum standard protection of intellectual property will be provided, so that trade between the countries will be easy. Even foreign direct investment, even some foreign investors also can come and invest, because it is the equal treatment. I discussed all those things in the previous slides, previous classes. So what is Bolar exemption? Bolar exemption, like it is the exemption that enables generic manufacturers especially generic manufacturers, so pharmaceuticals, to experiment with patented drugs and produce them in a limited quantities for research. Note that this is limited quantities for research, and is known as the Bolar exemption. So this is actually the subsection under the section 107A. So this is the actually which is enshrined in our Patent Act. Any act of making, constructing, using, selling, or importing a patented invention solely for use reasonably related to the development and submission of information. So this is very important. Development and submission of information required under any law for the time being in force in India or anywhere else in the world. So the Bolar exemptions is for, so any pharmaceutical company or any agrochemical companies, they can develop and submission of information for the regulatory approvals. So though the patent is the 20 years period is not over, the patentee 20 years period is not over, during this time still they can use the patent for the development and submission of information for the regulators anywhere in India, even in abroad also. For this purpose only, actually this exemption has been given. So any doubts in the Bolar exemption? Because so many people are asking some questions in the previous session about the Bolar exemption. So as I discussed, it is particularly beneficial for generic drug manufacturers, manufacturers of pesticides and fertilizers, and producers of medical devices. So these people actually normally for regulatory approvals, it will take some time. Even it will take sometimes 6 months to 2 years. So this our India is a hub for the generic manufacturing. So country like India, this kind of provision is needed. During the subsistence of patent, you can experiment and you can submit the information to the regulatory authorities. And once the patent is over, then you can come up with, you can launch the generic drug or pesticides or fertilizers or whatever may be, because you might have got the approvals in between from the regulatory authorities. And this provision is applicable not only in India, even abroad also. Even in abroad, if for the regulatory purposes, you can send that information. So this is the exception that is given by the Indian Patent Act, which came through TRIPS agreement. So next one is a prior use exception. So the advantage with prior use exception is it protects existing users from patent claims if prior to patent grant, and also preserves business that were using inventions before patent filing. That means before 2005. I will discuss further in next slides. The pre-use exemption in patent law. So actually, this is the unique provision introduced by the Patents Amendment Act 2005. So section 11A7 of the patent law says that. So I just wanted to ask one question to everyone, that so when can you claim the damages after your patent is granted? So from the date of the grant of the patent, or from the date of filing of the patent, or date of publication of the patent application,
From
or
the date of
request for
filing.
indemnity. Yeah.
From the date of filing.
Uh,
From the date of filing.
okay. Any other answers?
From the date of filing.
Date of
Date of filing. Okay. So it comes from the. So now you will get the answer. So provision section 11A7 grants patent-like privileges from the date of publication, even before patent is granted. But if you want
just a second, sir.
Yeah.
Excuse me, I'm sorry. So a date of publication, in the sense you're talking about the patent office publishing the,
patent application, not
patent application,
grant.
the patent. Yeah, patent office itself publicating the patent application, right?
A patent application after 18 months.
Okay, thank you.
First you will file a patent application. After 18 months, automatically your patent application will be published. So since then you can claim, but provided your patent should be granted. So hope this line you will understand. So you can sue the infringement after the grant of patent only, but you can claim the damages from the date of publication, as if, just one second. Yeah. So as if you will be getting patent-like privileges from the date of the publication, but you can claim the damages or you can infringe the suit after the grant of patent only. So this is very important point you need to understand. Even this is important for examination as well.
Can you please explain the difference? I mean, it is sounding a bit confusing, because you're saying that once the publication happens, the candidate is going to get patent-like privilege, but he can claim only after the patent has been granted. So
right. I will take one example, so for better understanding. So this is a date of filing. Very bad in writing. Okay, this is a date of filing, and this is after 18 months. This is the date of publication. So this is the date of grant. So actually you are a patent. You filed application in a patent office, and you are applicant, and your patent is granted. Now you are a patentee. So in between or after the grant of the patent, you came to know that one company or one guy who is infringing your patent. So you can claim, if you are sure that he is infringing from this date, or even infringing from publication, so you can claim the damages from this date rather than this date. See, normally after the grant only, you will get the right? Whatever the rights you're gonna get it, exclude others from making, using, selling, and importing. So these rights after the grant only will get it. But you came to know that one guy, see, after 18 months, maybe it took 2 years to grant of the patent. You came to know that before grant of the patent, one guy is infringing your invention. I mean, infringing your patent, because he is using your invention for product or process. So you came to know that, from last 1 year he has been infringing. You can you can claim the damages from date of publication onwards, or from the date when he started using your invention. And now, is it make sense?
Sir, here just the initial point, the confusion raised here is, so the date of filing of an application, the date of application, actually both two words, actually the ambiguity here will go. See, in the first time.
This is filing.
ROM has that is
this
a
filing. This is publication.
Okay.
After that, prosecution started. It has gone through all the pages in the patent office. Finally, one happy lucky day, your patent is granted, and it is published in the patent general.
Okay. Now
Here,
the question
here
here
it is.
is,
Now you tell me.
no, the damages can be claimed after this the first filing date, right? As Ram said.
Uh, After from the date of publication only you can claim, because I told earlier, like you are giving, patent is a quid pro quo, like you are sharing the knowledge and the government is giving the right. So patent like privileges you will get from the data publication only. You are disclosing it to the entire world on the data publication, not on the data filing. Actually, this is the secret phase. Nobody knows that I am you, and even patent office doesn't know that. Where is that pointer? Just 1 second.
So we can claim the damages
After the publication only, because this is the on this date onwards, entire world came to know that you have a patent, and you have an invention, and you have been filed that invention, and you are looking for the protection. So from this date onwards, you will get a patent like privileges, but provided you can sue the infringement after the grant of the patent only, or claim the damages after the grant of the patent. You can from back date onwards. That is what the provision it is giving. So this is very important. You need to know. That's the reason I'm explaining. I'm taking time and explaining. If you know,
Ashok, I just wanted to explain something here. Maybe people are confused about how can you claim damage from there. He just means to say that when you claim the damage after your grant, the amount will be calculated from the date of publication. It doesn't mean that when it is published, that day only you claim damage. It doesn't mean that. He means when it is granted and then you sue somebody, that amount of damage that you claim, you calculate that based on that date, not from the grant date.
because you are
then ma'am, what does it mean by you'll get patent like privileges from the date of publication? What does the term mean? Patent.
That's what it means, that when you have a patent, you can stop every other person, right, from making, using, selling, and all these things. But here, on the date of publication, you don't have the grant. But when you have the grant, you can claim the damage from date of publication, because it was open, it was available to public online. Anybody who is working on that invention, he could have seen that, but he didn't see that. That's his problem. But the patent owner can get the damage. So it says as if you got patent like privileges, grant like privileges you are getting from the date of publication.
And are there instances where I mean the application got published but the patent finally wasn't granted?
Yeah, most of the time it happens.
And whoever infringes in between from publication to grant, you can sue everyone once your grant is in your hand. So that's what Sir was discussing. If some big company infringes your patent, you are lucky enough, because you are getting patent like privileges from the publication, provided your grant is there. So after your grant, you can sue.
Okay, thank you.
So actually, this provision before 2005, this provision was not there. Through TRIPS agreement, just I will change the point. Actually, this provision came through TRIPS agreement. So we are compliant of TRIPS agreement since 2005 onwards. So whoever files patent before 2005, they won't get patent rights since from the date of publication. That is what these the two exceptions. They will get from the date of grant before 2005, as per our Patent Act. Whoever files, they won't get the patent like privileges since from the publication of the patent application. They will get it from grant of the patent. So whoever files before 2005, for them it is exception. So the sixth one is exhaustion of patent rights. So actually, exhaustion of patent rights exception, it limits patent rights after first sale or authorized distribution. This point I will explain in detail. Balance patent rights with consumer access to products. If you take, so we're gonna discuss about what is exhaustion. See, before we understand exhaustion, we need to know the doctrine of exhaustion. This is also called first sale doctrine. Actually, this has been enshrined in this section 107A, subsection B of the Patent Act. That's the reason we are discussing about exhaustion of patents. So, doctrine of exhaustion says that once the patent and invention is sold without any restriction, so your right is exhausted. That means, as per this doctrine, the first unrestricted sale of a patented item exhausts the patent is further control over that particular item is done. For example, you are a patent holder. Just one second. It is echoing. Dr. Anindya.
Ma'am, it is echoing and getting a resound also.
Okay. So, patent, where exactly I was. So, patent item exhausts the patent further. Patent is further control over that particular item. So, for example, you are a patentee, you are a patent holder. So, you have patentee rights on that particular item. For example, imagine that is a Samsung, some pen or mobile or whatever. So, once you sell that in your country, you have sold that one to someone, and you have sold it. You have sold it to some X. You cannot restrict X that if you want to sell it to somebody else, you have to take the permission of me. So that you cannot do, because doctrine of exhaustion will apply, because once you exploit your right and once you reap the benefits of the patentee rights, you cannot restriction and further sale, and you cannot control over that particular item. So that's the reason, if any patented item, for example, if you take a mobile, you can sell it to your friend, and if your friend wanted to sell it to someone, you cannot, as a patentee, you cannot control them, because the doctrine of exhaustion will. So further I will explain, because this is a very important topic and you will get the questions from this in the exam. So the rationale behind the doctrine of exhaustion is that the patent holder has already reaped the benefits conferred by the patent by exercising his exclusive right, because you already sold it. That means on the particular item or product, you already sold it. You reaped the benefits of the patentee rights. So that means your right is exhausted. So you cannot prevent others from, you cannot impose the restriction or control over the particular item in the subsequent selling. So if you can understand this one, I can explain a bit next advanced topic, because
sir, one question.
Yeah.
So let us suppose I am a patentee and I happen to sell it to someone else.
Okay.
Are you able to hear me, sir?
Yes, I can hear you.
So I sold my invention or patent to someone else. Does it mean that I cannot sell that to any more? I mean, I can't sell it to anyone else if I sold it once.
No, it is talking about you can sell it. It is talking about just what principle of exhaustion. It is simply like, once you sell your right, you cannot put the control on subsequent sellers, right? So that is what it is saying. Only that is what doctrine of exhaustion. That's it.
So hereditary selling means the
see, for example, selling. If you have a land, okay. So what is the purpose of the owning of the land? Because if you have land, you can sell that. So while selling, you cannot put some restrictions. So the basic, nobody will buy your land. So that is the basis of actually this Good and Sale Act. If you have land, so you cannot put the restrictions and the intellectual property, but there are some exemptions I am going to discuss. If you can understand this point, I can go to the next level. Hope everybody understand this. Yeah, you can ask the questions. Yeah.
But the ownership won't transfer to the second party, right? The person A, the patentee sold an item to the
if it is transferred, then only you will get the money. as a patentee.
Yeah, I got a money and royalty.
You got a
on
money,
that.
then that's it. Your
patent
on that product, on that product, your IP right is exhausted. Imagine that is a patent. So that guy freely can sell it to somebody else. So
yes.
Now I will explain the national exhaustion, regional exhaustion, and international exhaustion. So national exhaustion means some countries follow the national exhaustion, some countries follow regional exhaustion, some countries international exhaustion. So now, what is national exhaustion? National exhaustion means whatever the cell that happened, that is recognized as a patent. Imagine I am a patentee. I will recognize it inside the country only. Nation means inside the nation, inside the country only. For example, if somebody want to import same item, which I have invention, which I have patent on that invention, then I can prevent them. For example, some Samsung mobile is there. So I am a patent holder for that. So I can sell that one to someone. And any other person can import same Samsung. It is a gray, that's the reason it is called a gray products. It's not the black market product. I am not, this doctrine of exhaustion doesn't talks about black market products, something like, you know, some substandard mobile or substandard product where Samsung logo is there. No, I'm not talking about that. Exactly, it is produced from Samsung Korea only. So if that product is going to come into my country and my country follows national exhaustion, following national exhaustion means your patent act follows national exhaustion, then I can stop them. Further, whatever the doctrine of exhaustion I explained, there is a, so you can stop further control. I said, right, that the doctrine of exhaustion, actually you can stop patentee's further control over that particular item. But if our country follows the national exhaustion, so you still have control over the particular item. Coming to the international exhaustion, our India follows the international exhaustion. For example, the same example like Samsung. So if you can import, if any person can import from Pakistan, that is also Samsung product. So as a patentee holder, I cannot stop them, because in international exhaustion, entire world is treated as a single market. Once you sell your right to anyone, anywhere else in the world, your right is exhausted. So the same product, if you are importing through some other country, so as a patentee holder, you cannot do anything. You have to be silent because your right is exhausted. Your you reap benefits from your patentee right. So India is an international exhaustion, but before 2005, India was a national exhaustion. During that time, before 2005, national exhaustion, if same product, that means gray product. Why I am saying gray product? I hope you understand what is gray product and black market. Black market product means they put the same logo and substandard product. But gray products means it is from the same company, but it is coming through a different channel to your country. Those products also you can stop, because you are following national exhaustion. National exhaustion only recognize whatever in your country that has been sold, that only as a patentee I can recognize. Remaining whatever happened outside the world, I don't recognize. If same product is coming through different channel by importing or something, still I can stop, though I reap the benefits of the patentee rights. Hope everybody understand that. You can ask questions so that I can explain. This is the last topic. Hello.
Ashok ji, just let me put a scenario like that.
Okay.
See, or that way of my understanding.
Okay.
Suppose the country X sold an item, a patented item to the country B.
Okay. Yeah. Please go ahead.
Yeah. In that imported country can sell it to another country. So that is an international exception.
Please say.
Let us say US has a patent in India.
For example, it's very simple. Like in India, okay, you sold one product. Okay, you are a patentee.
Okay. From US.
No, in India only.
India only. Okay.
So if you want US example, I can take that also. First, because we are in India, it is easy to understand.
Okay.
Later, you can apply to other countries. So, for example, you are a patentee. So you have given some exclusive right to somebody. So he is a manufacturer. He is manufacturing your product. Once you sold, because you sell your right to this guy, so that he can produce the product, and you reap your benefits because you sold it to this manufacturer. So obviously, you might have given some money to you. So once you imagine, this is only one product, okay? So this product, now once you sold, as per the doctrine of exhaustion, your right is exhausted.
Okay.
That means this product, imagine I sold this product to some Pakistan, my friend is there. Okay. And same product.
Before that, when I given a right to the manufacturer, actually I exhausted the
right, because not only manufacturer, everyone. If you are selling your right, that means your right is exhausted. That is what.
Regional? Is it regional exhaustion? The initial step first.
No. I am not telling about national or regional. I'm going to come. Okay. So imagine. So I will cover all the exhaustions in this example only, so that it will be understood very easily. So now I sold the same product. This guy manufactured, he sold some same product to some in Pakistan. Okay. So he had that product. Everything is commercial. Okay. So I'm just giving one example. Okay. This is the commercially some products he might have sold to here. Okay. Here this product is, imagine this is a 5 rupees. So here this product is only 2 rupees. So any other person here in India, he can import same product for 1 rupee also. The same Samsung product for 1 rupee. So because obviously we are in Indian market, we always look for the cheap products. Okay. Cheap products in the sense like same product for the cheap price. Okay, I am getting the same product, but I can import. So this is international exhaustion. So as a patent holder, I cannot stop this guy to import this because my right is exhausted. Because my right is exhausted in entire world. Once I sell my right is over. That's over. Because I reaped my benefits. Because imagine India follows the international exhaustion. India follows the international exhaustion. For example, in the same case, if India is following the national exhaustion, okay, now I can stop this guy. Say, for example, I am a patentee. I sold my right to some manufacturer. Okay, so many products are there, and this has been sold to so many countries in the world, including Bhutan, even Sudan or something, where the product might be very cheap. Even if it is 1 rupee here in Pakistan, it might be 50 paisa only. Same product only. That's the reason I am saying grey product. It is not the black market product. So the same product you cannot import here if your country follows the national exhaustion, because the sale is only valid in your country only. Whatever sale you have done outside, this patentee does not recognize that. You understand? Hello?
So you mean to say that when the right is transferred to the manufacturer, so then there is a condition.
Your right is exhausted because the entire market is treated as a single market. Entire world is treated as a single market. Right.
So is there any condition? Okay. Is there any condition saying that actually it should not be imported from other country like that to get it the national existence?
National exhaustion before 2005, our India used to follow in patents national exhaustion only. So now we changed it to international exhaustion after 2005 because we all have to comply with the TRIPS agreement. So if national exhaustion means, that means this section. See, I will go to the section, maybe you will understand better. So importation of a patent products by any person from a person who is duly authorized under the, this is the current one. Earlier, duly authorized by the patentee, duly authorized under the law, become a duly authorized by the patentee before 2005. That means if you want to import the same product, you need to take the permission of the patentee. So before 2005, after 2005, you no need to take the permission of that. to produce and sell or distribute the product shall not be considered as infringement of the patent rights. This is called doctrine of exhaustion, and our India follows the international exhaustion. For example, if it is a regional exhaustion, okay, in the same example, for example, this is the European Union. I'm just saying, even Africa also you can take. European Union, so many countries are there. For example, you have a patent in Germany. Okay, this is Germany. So you can sell your product anywhere in the world. Okay, and even in this region also, to France, this is France, or this is UK. Imagine UK also in the EU region. You can sell it to anyone. Okay, and the same product, somehow it is coming back to your country through importation. Okay, you cannot block, because in this region, because as per the regional exhaustion, because entire Europe is following regional exhaustion. Okay, imagine. Okay, as per the regional exhaustion, you can import, because these are all part of European region. Entire European region is treated as one single market. But if any product, the same product only, if it is from out of the EU region, if this product is coming inside these countries, you can stop as a patentee holder. You can stop this product inside EU region, because the sale is only recognized in this region only. This is the regional exhaustion. Maybe if you go through the slides, you will understand.
At this point, that your whatever you are saying, that at this point of juncture, the product that is coming out of EU to Germany is not permitted, right?
It is permitted, because your sale is exhausted. Exhausted means like it is over. Your sale, because you sold your product to someone in EU region. The moment you sell, actually you get the money, because you exploit your right. Isn't it? The same product, it is coming through some other country other than EU region, then you can stop that. But if it is in the same EU region, you cannot stop that, because it follows the doctrine as exhaustion, regional exhaustion it follows.
So India sold to US, then US to India, it should not be.
It should be allowed, because India follows international exhaustion. Entire world, it is treated as a single market for India. India thinks that entire world is a single market only.
Right. If that
because we follow international exhaustion. It doesn't matter you sell US or Uganda or some any country in the world. Okay, if you sell the same product is coming back to you, or similar product which is of the patentee having right on that in different country. So if you are importing, it doesn't matter. You can import, because we follow the international exhaustion.
Yes.
1 second, sir. I just want to get clarified.
Okay.
Let us suppose I'm granted a patent in my home country. Now, can I sell this patent rights to anyone else?
Yeah,
I mean,
you can.
to any company in any country?
Yes.
Though I got the patent rights only in India?
Yes.
All right. And since the patenting is...
Why would you sell your patent right to some other country? Why some other countries will ask you? Because the right is valid in your country only.
Right.
Unless you file patent in that country and it is protected, that guy will come and ask you. Something like Samsung Korea, his rights is protected in Korea and as well as in India. That's the reason he is selling Samsung Korea mobiles. We are using mobiles that we are buying here. The same mobile, if it is coming through different channel, and if our India is a national exhaustion, imagine India is an international exhaustion. Okay, patentee, that means Samsung, because he is also having patent here, he can stop that Samsung mobiles, because imagine this Samsung mobile is 10,000 in India. Okay, if our country is following national exhaustion only. So some Bhutan or something where Samsung is having a right there also, or if they don't have right also, they are having this same Samsung products which are of 7,000 rupees only. So those Bhutan guy, they can sell some Samsung mobiles in India. That means you are importing to India with 8,000 rupees only. So as a consumer, I don't want to buy 10,000 one, because I am getting 8,000 one, right? the same product, Samsung.
Right.
Yeah, so we allowed, India allowed that one, international exhaustion, because we don't want to give a monopoly to patent holder. So by stopping subsequent rights also. So we look for the welfare of the public. So ultimately the consumer, that means we, get the best price for the same product. I don't want to buy to Samsung, what is that? Samsung showroom and spend 10,000. Through some other way, if I am getting, through some, if it is non-Samsung showroom also, if it is at 8,000 rupees, I will go and buy that, because my country follows the international exhaustion. So patentee cannot stop other guy, other than Samsung showroom, other seller is there, right? So you cannot stop that. I mean, Samsung patentee guy. You understand what I'm trying to say?
Yeah.
Like all these e-commerce sites like Flipkart and Amazon, they're all following.
So totally I covered. So I covered, all these exhaustions. If you have any questions, any kind of questions, not only this, in any previous topics also, you can ask, feel free to ask. And if somebody wanted to write a patent agent exam as well, so we can guide, because there are two patent, me and Aninja, we both are Indian patent agents, and we can guide them.
Question in the chat box.
Oh, there are questions? Okay. This is the one, how any patentee is being exploited. That is how he knows. So what do you mean by this? Prasad, DKS. So anyway, how any patentee is being exploited. That is how he knows. So basically the infringement you are talking, I guess if somebody infringes your patent, that's what ma'am said, if it is a product or if it is a process. So if it's process, then they have to prove if it's the product and yes are in the market. Yeah. So if it is a similar product, then you can come to know that there is infringement. So similar kind of technology, unless you see the claims, you cannot clearly say. But if you are an inventor, definitely you can say that. If you are applicant, you can say that if some product, similar product comes in the market, and by comparing your claims, by seeing your claims exactly, so you can assess the that product is infringed or not, or process as well. Sir, if I sell rights to an ex-company person, can a B person use it or copy my product without any permission? So if I sell a right to an ex-company person, use my product without any permission from me or ex, it is infringement, right? Exactly. For commercial purpose, if you use, yes, it is infringement. Any legal hair will get that. Yes, any legal heir will get the patent benefits. Yeah, there is a section in the Patent Act that talks about if patentee or applicant dies, what happens? Yes, there is a section. Right. File in India first and then.
I am typing that. That is the answer.
Okay. Fine. First filing date at the IPO or local agency. What does it mean?
Ashokji, it is connected to the Prasad's question. So Madam has answered like a legal hair will get the patentee benefit.
Okay.
So after getting the grant, then he will get the legal hair. But in the prosecution stage itself, also will the same benefits will continue and will get with the legal hairs.
Come
if
again? What?
If in the prosecution.
Okay.
So in that case also the legal hair will continue the benefits?
Yes, sir. Absolutely.
Not only after the granting, just after the publication.
Right. Exactly.
that section that he was talking about, and there is a specific form also, form number 10 and section 44, that exactly talks about after grant and when the person has been deceased, when the patent holder is deceased. But in general case also, there is no separate section for that, but a legal here can proceed with the prosecution.
It is like, I wanted to make it clear. It is something like, it is like a normal right. So it is intellectual property right, patent also. So definitely, these rights, if a normal property, the way how it works, even here also it will work. So definitely, section 44 of the Patent Act, amendment of patent granted to deceased applicant, you can go through that, section 44 of the Patent Act.
Thank you.
So today is the last date of all the lectures. This concludes our lecture session. Tomorrow you have your exam in the first half, and then the feedback and valedictory in the second half. So if there is any question regarding anything or any confusion regarding anything, you can ask here, because tomorrow in the first half only you have exam.
Is it an objective mode, ma'am, or
yes.
So there will be 50 questions, 2 marks each, total 100 marks, and that will be in Google form. So we will share the form when we start the meeting. We will share that form in the chat box. So yeah, and there will be the time. How much time should we give? 1 hour? How much you want?
Half day means half day. 50 questions, 50 minutes, 1 hour.
And for all the participants, maybe, some people who are not in the group. So for them, please go through the slides, especially, what are the slides I have covered and what are the slides ma'am covered. These are the very important slides. So if you can cover basic things, that is more than enough to answer the question. So now my slides I will be sharing, and day 3 also I have taken one class. That slides I shared already, and ma'am slides also we have shared. So if you can concentrate more on these 3 classes, so mostly you can cover. So I'm giving the hint. Okay, mostly you can cover.
And while writing the exam,
right.
sir, while writing the exam, should the candidate have a webcam?
That's not mandatory.
That's not mandatory.
Okay, thank you.
So open book exam, so that's not mandatory. Okay.
The purpose of taking the exam is that you learn the subject well, because this is a certificate course. If you learn it well, it's well and good. If we are giving it open book because maybe you were not able to read